I was one of the few clerks who realized that I was in fact a clerk. And clerks basically are at the service of their justice. They basically do anything the justice asks. Most of what they do falls into reading cert petitions for review in the Supreme Court, and helping in the writing of opinions. Sometimes they'll also write speeches or organize other events for the justice, but principally it's cert petitions and opinion writing. And on opinion writing, it runs the gamut of what a clerk might do. Justice Scalia, for example, if you pick up any of his opinions from the webpage, you can instantly tell, even if the name of the justice is erased, that it's a Justice Scalia opinion. He has a very distinct writing style. Why? Because he assigns his clerks to prepare a first draft of whatever opinion is assigned by the Chief Justice or the Senior Justice in the majority to him. The draft will come in on his desk, and at least in the early days, also a cart with every book or other authority, other than a Supreme Court opinion, because he's got a set of that in his office, with every book or other authority on the cart with a bookmark in it to the page that's cited, because he will actually do his own work. And he'll go through the opinion, he'll rewrite it, he'll read every authority. It's really his opinion at the end. At the other, I guess this may be a similar point, Justice Stevens, for whom I clerk, took over from William O. Douglas. Douglas had a very different way of working with his clerks. He wrote his opinion from scratch and left blanks for citations. Now, it caused a problem, as I understand, if there wasn't actually any authority to fill in at the end of the sentences. But that did not stop Justice Douglas, and that's the way the opinions came down. Judge Friendly, he wrote all of his opinions on yellow legal paper and then gave it to his clerk to work on. For me, with Justice Stevens, he had the exact opposite approach. He would actually dictate the first draft of the opinion himself. There were parts that you understood very soon after working with him that you could not touch and edit, regardless of what improvements you thought you might bring to the opinion. And then there was a part, usually more or less in the middle, where you would do your work. Justice Stevens had a couple of clerks, so we got to work very closely with him. He now has 4, and you work just very closely with the justice in getting those opinions out. I think on some cases, and I think it's true with probably the abortion cases, the justices would have well considered the authority in the prior cases and precedents in that area and their own views, and it's probably very difficult or only at the margins that you could have an effect on a justice's opinion on an abortion case, for example, separation of powers cases. So I think that's true. I think it's an overstatement to say that in every case that comes before the court that it's prejudged, or the justices are set in their ways before the advocates argue. What I think a lot of people don't realize is of the 60 to 70 cases that come before the court each year, there are only a handful of cases that really grace the front pages of the New York Times or the Washington Post. The primary selection method for getting cases before the court is whether there's a split in the circuits. Most of those cases are statutory cases that are only barely interesting to the vast majority of people, sometimes even to the advocates before it, because they're very minor issues of textual construction. So on those issues, I think it's fair to say that you can have an enormous impact on the court, and good or bad advocacy can determine which way the court decides. I'm reminded of that in one particular example, and it relates to something we've read in the papers these past days. I don't know how many people saw, I think it was in the front page yesterday, about the mistake that was made in Justice Kennedy's opinion in the child rape case. Well, at the end of the term, needless to say, there's an enormous amount of work that needs to be done. The clerks by that point are very knowledgeable about the court's docket. They're at the peak of their efficiency, but nonetheless, there's an overwhelming amount of work to get done, and it's actually less now than it used to be, because the court handles 60 to 70 opinions per term now. When I was clerking for the justice, the court had on its docket, it's basically a full capacity of about 150 cases a year. So the end of court press was overwhelming, and the way these cases get decided is in There's a vote taken right after the oral argument is heard. Every justice says how he wants to come out and why in more or less detail. The senior justice in the majority, which is usually the Chief Justice if he's in the majority, or now my old boss, Justice Stevens, will assign the opinion to another justice in the majority. Well, that opinion is then drafted and circulated, and what it then elicits is typically a number of one-line, please join me letters. And literally that's what they say. They say, you know, dear Justice Stevens, please join me, Terry Blackman, or whomever. Sometimes the opinions at the end of the term will not be of the same quality that prior opinions were. And it's also interesting for those who do oral argument, no matter how well you put things together in your briefs, and no matter how much you try to make your reply brief sort of encapsulate the important things and do what you would do at oral argument, it's never the same as the epiphany you usually have shortly before you, or during the time you're preparing for your oral argument and when you get up and speak to a court. The question was, do you get a chance to know some of the other justices and who were some of the personalities during my term, which is the term I clerk, which is the last term of the Burger Court. Since each chambers had at least two, in just the case of Justice Stevens, or typically four law clerks, there's an unfortunate tendency for the chambers to function as 9 little law firms, and there's not as much interaction among the justices as you might think. In order to promote interaction with the law clerks, we had and I don't know who created it, but it was a great idea, a Take a Justice to Lunch program. So you'd have a group from 8 chambers, or we would usually get together with one of the other chambers since there was only two of us, and we'd take a justice to lunch. And they were all really wonderful people. Frankly, one of the larger personalities was the late Chief Justice Rehnquist, who was very funny, very free to dispense advice, and a really nice guy. He sticks out in my mind. But yes, there was that opportunity, but it was very limited. And sometimes with the more talkative or friendly justices, you'd see them in the Supreme Court building off hours, like Justice Powell, for example, was very courtly, and he would chat with you if he happened to see you walking around, early in the morning or late at night, and would usually have something very nice to say about how you're working too hard and you should take a little more time off. But